Chairman, I was in federal court when the proceeding that Mr. Waterman brought into federal court in front of Chief Federal Judge Donald Malloy. And Judge Malloy clearly indicated that he had problems with Montana's system of lethal injection. And without getting into attorney-client privilege, I can tell you something about the execution of David Dawson, and I can also speak from my experience in homicide cases. Under the current statute, the Montana statute provides for using two drugs. The first drug puts the person to sleep. The second drug starts delaying their lung action. Because, I believe, of issues with those two drugs, the protocol that's used by the Department of Corrections, which is not allowed by the statute, which Judge Malloy pointed out is one of the problems in Montana, provides for the administering of a third drug. That third drug is administered because the person, after that second drug is administered, is asphyxiating. And I can tell you in the case of Mr. Dawson, I heard all of the witnesses say that after those first two drugs were administered, he was snoring before the third drug was administered. Any medical examiner would tell you that in cases of asphyxiation, be it mechanical or physical asphyxiation, snoring is a clear indication that the person is suffering and trying to regain their breath. So I do believe it is most likely that the Ninth Circuit will rule that this method of execution is improper. It then will be a question of whether that's going to be binding on the state of Montana. I agree with Mr. Waterman that, I mean, we're under their jurisprudence. But in my experience in death penalty cases, the Ninth Circuit has also said in Summerlin that these issues about whether the death penalty should be imposed have to be decided by a jury. Montana law now provides that that be decided by a judge. The Montana judges have chosen, at least at this point, not to follow the direction of the Ninth Circuit.